Good afternoon, everyone. My name is Craig Stodmeyer. I'm a partner here at Nauman, Smith, Shissler Hall. I'd like to take this opportunity to welcome you to our series of webinars in 30 minutes. Today's topic about bankruptcy and Subchapter 5. The main presenter today is going to be my colleague, Ted Benchik, whose handsome face you see on the Zoom link here. Ted is an experienced lawyer and has practiced bankruptcy law for several years and is going to talk to us about Subchapter 5 and the various reasons for and nuances of. Before we get into that, though, just a couple of housekeeping measures, which I'm sure a lot of you are used to now with Zoom type things, but just to go over them. First of all, you did hear a message at the beginning that the seminar is being recorded. Don't panic, though, in terms of video. The only video that will occur would be Ted's and mine, so you're safe there. Also, we ask that during the presentation that you keep your audio off or mute your audio, and it's up to you whether you want to leave your video up or not. But please mute your audio because it helps with background noise and the like. We welcome questions during the seminar. In fact, we would strongly encourage you to ask questions. And that's what part of this process is for. If you do so, please use the chat feature, which is located down in your toolbar. And one of us will see it and pass it on to Ted or myself, and we'll go from there. At the end of the program, we will, if there are any questions and you haven't gotten a chance to type it in or you just haven't been able to do it, we'll hang on for a few more minutes and you can present questions that way. Because we do want to, I don't know about the rest of you, but one of the things I hate is going to a seminar that I think is on a topic and I have all these questions. They talk for, whatever period of time and don't answer any of the questions that you had. So that's part of this whole process. We hope that you'll pick up some useful information today, and I'm sure you will from Ted. And then finally, after today's program, sometime by the end of this week, you will receive a copy of the recording if you missed something or would like to go back over something. And it's also going to be posted to our website if you would want to go there, and that is at www.nssh.com. That's www.nssh.com. And also, I would invite you to take a look at our LinkedIn page for Nauman Smith, because Ted wrote a very interesting article on another aspect of bankruptcy that I think that you will find interesting. So, without any further ado, I'll turn it over to Ted.
Thanks, Craig. Good afternoon, everyone. I'll be talking this afternoon about Subchapter 5. And for those of you who have some familiarity with bankruptcy, maybe wondering, well, what's 5? You've heard of 7, 11, 13, a couple of others, but what's Subchapter 5 about? Well, Subchapter 5 is actually part of Chapter 11. It was brought about as a result of the Small Business Reorganization Act of 2019, then subsequently amended in 2020 by the CARES Act. The idea behind Subchapter 5 is that there had been some fact-finding and bankruptcy trustees had received word and reported back that few of the problems with Chapter 11 in its kind of traditional format was that it was too expensive and burdensome to small business debtors. One of the features of a traditional Chapter 11 is the debtor has to pay not only for its own counsel and financial advisors and associated fees, but also has to pay the fees for the creditors committee and its professional expenses. And the creditors committee, for those not familiar, is usually made up of the 20 largest creditors holding unsecured claims. Their job is basically to kind of monitor the case on behalf of the other unsecured creditors. So,
and if I could ask you just for those some of the watching, can you give us some examples of an unsecured claim as opposed to a secured or priority claim?
Sure, Craig. A secured claim is one in which the lender retains a security interest in the collateral. So for most of us, the examples we'd be familiar with would be your house has a mortgage. That is a secured claim. If you purchase a car through the financing that's available at the dealership, that is also a secured claim. If you basically, if you don't pay on a secured claim, the lender can take the collateral back through repossession. An unsecured claim is essentially everything else. It's money that's owed to a creditor, but the creditor does not have the right to just summarily repossess the collateral in the event of non-payment. So, and the idea here is that secured lenders in bankruptcy, because of the stakes, usually have their own counsel. They're usually highly motivated to monitor the case and protect their interest. With unsecured creditors, since they don't have that possessory lien on the amount that's owed, or it's not secured by collateral, the idea here is that the creditors committee looks after the interests of all the unsecured creditors, because individually they tend to be owed a little bit less, even if in the aggregate they're owed a lot more. But so the creditors committee essentially represents the interests of all the unsecured creditors. But as a committee that's formed, and they can hire their own counsel, they can hire their own accountants. If there's any forensic tracing that needs to be done, other professional fees, appraisers, that kind of thing, those kind of expenses all had to be paid by the debtor in addition to the debtor's own expenses. So this becomes very pricey, very expensive, very quickly, especially for a small business debtor. The other problem was perceived that Chapter 11s took rather long to administer. We'll get into a couple of the reasons later on, but just the timelines that are involved. There's an exclusivity period in which the debtor can file its own plan, and then afterward, other creditors can file competing reorganization plans. And this had the effect of dragging out the case. The longer the case drags out, the harder it is for a debtor to get financing to continue its normal operations. So while this is all playing out, the debtor is not only spending all of this money on its own counsel and the creditors' counsel, it's also going to have a hard time getting financing for its day-to-day operations while the case is being dragged out. So what Subchapter 5 was intended to do is, one, streamline the process. It's supposed to make Chapter 11 reorganizations for smaller debtors move a lot quicker. And that is a stated goal in the legislation. It's also designed to be less burdensome, more specifically, reducing costs to a debtor of being in Chapter 11. So they should be in it shorter, and they should have to spend less money while they're in Chapter 11 and Subchapter 5 of Chapter 11. So who is eligible to file for Subchapter 5? Well,
and Ted, that's what I was going to say. Now that we've talked a little bit about what Chapter 5 or where it comes from, in terms of what type of debtor would be best suited for something under Subchapter 5.
Yeah, and that would be to the next slide, please. Yeah, these are the way that Section 101.51D defines eligibility, Craig. This sets forth, at least in legislative language, who is a good Subchapter 5 debtor. First of all, it has to be a person, which, if you remember all the controversy about Mitt Romney and corporations or people, well, actually, the Bankruptcy Code defines person as also including a corporation, but it has to be an entity that's engaged in commercial and business activities, has aggregate non-contingent debts of less than or equal to 7.5 million. Now, that number, when the legislation was first enacted, was about 2.7 million. So then, as a result of the CARES Act in 2020, the debt limit was pushed up to 7.5 million. There was a provision in the CARES Act, though, that called for that higher debt limit to go back down to the 2.7 million figure in March of this year, which did happen. Then in June, President Biden signed legislation that raised the debt limit back up to what it had been under the CARES Act. So now it is available to debtors with less than $7.5 million in aggregate non-contingent debts. What does non-contingent mean? That's a debt that has basically been already decided, determined. It doesn't address potential debts, usually in the context, say, of pending lawsuits where you don't know what the damage figure might be, or even if there's going to be any damage figure. But non-contingent debts are ones that are usually pretty well decided. You know how much you owe on the mortgage, you know how much you owe to the bank for your payroll financing or inventory acquisition financing. Also, greater than or equal to 50% of the debt must be related to business activities, because some debtors eligible under Subchapter 5 could be individual sole proprietors who may have business and personal debts or personal guarantees on some business debts. But this ensures that at least more than half of the debt is related to business. So this isn't available to, say, an individual who has no business debt or very little business debt.
That's just to clarify, because that's actually a question you anticipated I was going to ask in terms of the entities that can file under Subchapter 5. That would include an individual to the extent that they're engaged as a sole proprietor? Or...
Yes.
Okay.
Absolutely. It's available to sole proprietors, partnerships, LLCs, sub-S corporations, C corporations. All of those entities are included within the definition of a person as the bankruptcy code is concerned. So yeah, all of those kind of business forms, a sole proprietor, someone running a business, just out of their house, doesn't even have to be full-time, but as long as more than 50% of that person's debt is related to the business activities, that person, that natural person, is also an eligible debtor under Subchapter 5.
And is that what helps distinguish this from a Chapter 13?
Right. A Chapter 13 is only available to individual persons. No businesses, no corporate entities are eligible for a 13. You have to be an actual living, breathing human being person to file a Chapter 13. But Subchapter 5 of 11 expands that definition to include, again, individual persons, but also partnerships and corporate entities as well. Thanks. And again, just as a quick reminder, Craig mentioned this at the start, if you have any questions, go ahead, type them in the dialog box, and I'll hopefully have some time left over at the end, but field live questions if you have them. Subchapter 5 is not available for a single asset real estate business. So if you buy a house and you're a landlord and the corporation only exists to own and to rent out that particular piece of real estate, then you would not be eligible for Subchapter 5. Now, could you have a holding company that owns several pieces of real estate? I think the answer is yes. The statute specifically carves out single asset real estate businesses. So if you've got two pieces of property in a corporation, then I think you're eligible under Subchapter 5. Also, basically any publicly traded company is not eligible for treatment under Subchapter 5. And as a matter of practicality, most bankruptcies involving publicly traded companies involve debts that are usually well in excess of $7.5 million. So that would be another way that would prevent a large publicly traded company from getting treated under Subchapter 5. They usually carry much more debt than that. Debtor must make an affirmative election to be treated under Subchapter 5. It is not something that comes about as a result of default. If a debtor files under Chapter 11, unless they elect treatment under Subchapter 5, they're going to be treated as though they had filed a traditional Chapter 11, and then things like the creditors committee will start forming up, and so that has to be made known from the outset.
And Ted, is there any limit on when you have to make that election, like within so much time, or is it more a practical limit than a statutory one?
I think it's more of a practical limit. You would certainly want to get that known to the court before, the kinds of things that go along with Chapter 11 cases are done. You don't want to say once the creditors committee is formed, oh, now I want to file Subchapter 5. I don't believe there's a specific deadline, but I think that the forms that have been issued now provide for election under Subchapter 5 at the time of filing. And I think you'd be well advised to just go ahead and take that election right out of the gate.
Okay.
And then debtor's duties under Subchapter 5, I've got them listed here. There's some overlap with a traditional Chapter 11. You have to file a balance sheet, statement of operations, cash flow statement, and federal income tax returns. This sometimes becomes a problem, especially when you're dealing with very small businesses or sole proprietor or single member LLCs. Sometimes folks get behind on filing their taxes. You got to make sure that those are current as of the time the case is filed. Because I've had cases where the bankruptcy trustee was very soon after filing saying, where are the tax returns, where are the tax returns? Then I found out from my client that he hadn't filed them in 3 or 4 years. And so I had to scramble when he had to be taking care of other things in order to get the tax returns pulled together. So that's one of those kind of pre-filing things you want to make sure, especially if somebody's had a business that's been faltering, they're probably not minding that aspect of their operations as carefully as they should. So make sure that that's all caught up. There also has to be periodic financial reporting, projected cash receipts and disbursements. Those again are features of traditional Chapter 11. These are basically ways to inform the court and the creditors that this business, if it plans to reorganize, has some kind of wherewithal and means to do so. And also going forward, timely tax returns have to be filed and copies provided to the trustee. As far as how cases are administered under Subchapter 5, I mentioned just a few moments ago, the forms that are associated with filing Chapter 11, the petition, and some of the other documents that go in have been revised to integrate Subchapter 5 provisions. There's also a space for electing Subchapter 5 treatment in the petition. So that's already been worked out. I also mentioned earlier, there's no unsecured creditors committee unless appointed by the court. So it's not as though there can never be one. Subchapter 5 legislation takes into account that there may need to be a creditors committee, but the U.S. Trustees Handbook says that's something that should only be done in highly exceptional or unusual cases, because again, elimination of that committee was one of the goals of the legislation. Also, to those who have been familiar with Chapter 11s before, you'll recall that every quarter there was a fee that was owed by the debtor to the U.S. Trustee's Office to compensate the Trustee's Office for the work that it did to monitor the case. That trustee's fee has also been eliminated as a result of Subchapter 5, which is a major benefit to smaller businesses, because smaller businesses need pretty much every dollar they can get their hands on just to keep their operations going, and eliminating that is a major plus. Also, after the case has been filed, there's a status conference that has to be called within 60 days. 14 days prior to the status conference, the debtor files with the court describing the efforts taken or that will be taken to attain a consensual plan of reorganization. We'll talk a little bit in the next couple of slides about the reorganization plan, but what Subchapter 5 is intended to do is to get the debtor and the creditors working together very early in the process to come up with a plan that is consensual, that is agreed to by as many of the stakeholders as possible. Again, in traditional Chapter 11, sometimes you get into situations involving competing reorganization plans. Sometimes it gets very contentious because there may be a class of creditors that feels that it's not being adequately provided for, or that something called the absolute priority rule isn't being followed. This is designed to eliminate that and to get the reorganization plan put together with as much input and cooperation of all the creditors and classes as possible. The debtor has to file a reorganization plan within 90 days. That can be extended for good cause shown. This, again, has an echo in the exclusivity period. But in this situation, in Subchapter 5, the debtor files the plan. The creditors do not get to file the plan even after the 90 days period is up. only the debtor can file that plan, and the deadline to file the proofs of claim is set by the court, just as in a regular Chapter 7, 11, 13. Court sets that. I just wrote an article that was put on the firm's website and was referenced earlier, involving a case involving U-Haul's bankruptcy in West Virginia, in which there was a class action pending with $53 million of claims asserted against U-Haul. Class counsel could not file the proof of claim by the midnight deadline on the date that was set by the court, because the person who was going to be filing didn't have proper login credentials. So the next morning, the proof of claim was filed, and the court said, too bad, class counsel, you're out of luck. Your $53 million claim is now gone. So very important to meet that deadline. It is not extendable, and failure to do so within time is going to be fatal. As to how property is treated in Subchapter 5, just as in 11, the debtor retains possession of the corporate assets. An automatic stay is in effect. So creditors, even those creditors with secured claims, can't engage in a feeding frenzy and just start grabbing their collateral. The debtor remains in possession, subject to the protection of the automatic stay. A creditor who wants to obtain estate property, will have to do so via a motion for relief from the automatic stay, just in any other kind of bankruptcy.
And you had mentioned, I'm sorry, you had mentioned earlier that the trustee's office still remains, involved to some extent. What's the role of the trustee now under Subchapter 5?
Yeah, the role of the trustee is somewhat similar than in all the other cases, but with a couple of twists. As in any other bankruptcy, the trustee's office, by the way, just real quick for those who may not be aware, in bankruptcy, an office of the Department of Justice called the Office of the Trustee is a person, attorney, who does not represent the debtor or the creditors, who oversees the administration of the case on behalf of the Department of Justice. The trustee is a neutral and is, again, employed by DOJ to oversee and monitor the case, to investigate financial and business aspects, files a statement regarding their investigation. They also monitor the case for anything that looks like it may be improper. Bankruptcy fraud cases have kind of popped up more recently on the Department of Justice's enforcement radar. So if any assets are being concealed, or debts are being misstated, or if it looks like there's anything going on that's improper, the trustee investigates that, and if necessary, makes a referral to the Department of Justice for whatever prosecution it may want to engage in. I have fortunately not been involved in any cases where that became an issue, but it's always a good idea to make sure that when you're sitting down with your client, that you communicate the importance of being very candid and open and transparent about what the assets are, who you owe money to. You can't leave creditors off the list just because you want to take care of them outside of bankruptcy. Even if it's well-intended or in good faith, it's still a crime and you can't do it. So trustee looks for that kind of stuff. Trustee can also appear in the case and be heard on specific matters regarding valuation of property, subject to liens from creditors, issues relating to confirmation of the plan, any post-confirmation issues that arise, sale of estate property, and also participates in the status conference. So the role again, this is very similar to what you would encounter in 7s, 11s. What the trustee is also supposed to be doing in Subchapter 5 that's a little bit different is their goal, consistent with the legislation, is to facilitate entering into a consensual plan of reorganization between the debtor and the creditors. The trustee's manual specifically states that consensual confirmation is a goal of subchapter 5 and that the trustee should take steps to encourage that outcome. Now, I guess it depends on the personality of the individual trustee. Some might be very aggressive and arm twisting and trying to get the parties to come together. Some might take a more laid back approach. That's just like in any other situation involving the trustee. Their own personal preferences and personality might affect how that plays out. But at least the goal of subchapter 5, as set forth by the DOJ in its manual, is to encourage this kind of consensual, cooperative, collaborative process rather than letting it degenerate into a highly adversarial reorganization. So you can see that the trustee is really considered more like that of a guide or a gatekeeper than say like a referee or an umpire, which is often what it becomes in other forms of bankruptcy. So just to move into the confirmation process, like I mentioned before, only the debtor files the plan. Creditors don't get to file a plan. There's no disclosure statement required in subchapter 5. Those veterans of chapter 11 know that a disclosure statement filed by the debtor is a very detailed document that describes current business operations, makes several projections about future business operations, and really kind of functions and is subject to similar rules as a prospectus in a securities offering. That's no longer required because it takes a lot of time and a lot of money to put one of those together. But the plan does have to include a history of business operation, some kind of a liquidation analysis, basically summarizing if we had to sell everything off, here's how much would be available to creditors. Typically that amounts to pennies on the dollar at best. And then some projections to sustain the proposed plan payments, basically where we think the money is going to come from. The plan should also provide for submission of all or such portion of future earnings or other future income of the debtor. This is where subchapter 5 starts looking more like chapter 13 for those who are familiar with that. And in chapter 13, an individual person has to commit to paying all of their disposable income toward funding the plan of reorganization. So this language kind of takes from chapter 13. Administrative expenses, again, they're much lower in a subchapter 5 than in a typical traditional chapter 11, but there will always be some. Those can be paid over the term of the plan. The absolute priority rule doesn't apply. Really quickly, absolute priority rule basically says that all creditors within a superior class have to be paid off in full, in total, before any money can be paid to creditors of an inferior class. So that means that the secured creditors have to be paid everything that they're owed, every last dime, before any funds are available to be distributed to the unsecured creditors, usually resulting in essentially de minimis types of distribution to unsecureds. That no longer applies in subchapter 5. So a plan can provide for non-full payment to a secured creditor, and we'll get into consensual and non-consensual plans later, and without worrying about the strict and harsh application of that rule. The plan, however, must not discriminate unfairly and has to be, quote, fair and equitable, end quote, with all classes. Okay. Discharge in a subchapter 5. If all the creditors agree, or classes of creditors agree to the confirmation of the plan that's been proposed by the debtor, then the discharge is granted upon confirmation of the plan. And then the debtor makes direct payments to the creditors under the terms of that plan. That's when you have a consensual plan. And again, getting to consensual plans is the stated goal of subchapter 5. There will be situations in which the creditors may not agree with the terms of the proposed plan, but a plan can still be confirmed on a non-consensual basis, so long as it does not discriminate unfairly. The plan is fair and equitable, and the court approves. Now, one feature of a non-consensual confirmation of the plan is that for folks who have been in Chapter 13 cases are familiar with this concept, that plan can provide for cram down. Cram down means that the value of a claim can be reduced to the value of the collateral regardless of the actual amount that's owed. So this is where there's a strong incentive built in to get the creditors to agree to a consensual plan, because if it's a non-consensual plan that's approved by the court, then some creditor will probably wind up having their claim reduced, perhaps substantially, via this cram down provision. If the plan is confirmed on a non-consensual basis, the debtor doesn't receive the discharge until after all of the plan payments have been made. Those plan payments that usually the plan period runs from 3 to 5 years, more often closer to 5 than to 3.
So Ted, we have about a minute left.
I'll talk real fast. I just got one more slide.
We're looking at how Chapter 11 and Chapter 5 differ. You hit on several of them. Just want to hit the highlights here.
Yeah, so I'll just kind of go through this, really quickly. And of course, you'll have access to these materials yourself. But I mean, just as a kind of side-by-side comparison, we've talked about that, there's no creditors committee in a Subchapter 5, no disclosure statement required, can't have competing plans like you would in a traditional Chapter 11. Absolute priority does not apply. You can have confirmation without the consent of all the classes. And again, that will trigger some cram down provisions, which again strongly encourages all the creditors to get on board. And you don't also have plan voting, which is a feature of Chapter 11 cases that can also add to and cause much greater expense and delay by having to go out and get the approval of different creditor classes. That's not required anymore in Subchapter 5. So I know I've taken up most of my time. I will take any questions anyone has for a few minutes, though. I don't know what time-wise.
See, Ted, you did such a good job. I don't see any in the chat function, but Sarah has posted a notice to everybody that if you still have questions, that you certainly can email us. Our email addresses are at the bottom of the presentation there. Ted, thank you very much. That was very informed about a new chapter in the Bankruptcy Code, which is always exciting. Once again, to remind everybody, if you're logged in, or registered, you will receive a copy of the recording in case you missed something or had to jump off right at 12:30. And certainly, if you have any questions, Ted or I would welcome answering them. Our email addresses, once again, are shown. We thank you for your attention and ask you to read Ted's article on LinkedIn about the U-Haul bankruptcy. The $53 million unsecured creditor is going to be very sad. Thank you again for attending. We ask you to keep in tune for future webinars. Take care. Have a good afternoon.
Thank you.